Hey guys, Toby Mathis here, and today we're going to talk about the top 8 lawsuits that real estate agents are having to deal with in 2023. All right, we've had a downturn in the market in some marketplaces. Some, they're actually up, but what we have is a slowing of the entire real estate market, and that's because interest rates have gone up and people are scared and builders are stopped building. They're slowing down, if not completely stopping in some cases. But what we've seen is a downturn. I don't care if it's 1%, 2%, or close to even, or just not keeping pace with what we were seeing in 2020 and 2021. We are not growing nearly as fast, and it slowed down considerably, which causes people to have regret because they may be purchasing on the idea that this market's going to be hot, and now they're looking for somebody to blame, and God forbid they actually did some inner reflection. Most people like to blame somebody else, and there you are as a real estate agent squarely within their target area of who to blame other than themselves. And so I want to be very clear about this. These are the legal claims they're making. I'm not saying that they're meritorious or making any allegations against somebody. I'm just saying this is what we're seeing, and then I'm going to give you a couple solutions for how you can minimize these things from having an impact on you. And so I don't care if you're a real estate agent, broker, salesperson, wholesaler, whatever. If you're in the world of real estate and you're involved in any way in somebody purchasing something and then they have regret, they like to sue people to try to recover monies that because of their own problems that they lost. Because again, in this country, sometimes we don't take personal responsibility, we take it out on other folks. And so we want to find ways to minimize these things impacting you. So let's just go through them real quick. Number one, breach of fiduciary duty. What is a fiduciary duty? First off, real estate agents have a duty by law to put the interest of their clients before their own. And so the easiest thing for a client to do is say, hey, you were more interested in making a commission than in looking out for my best interests. And here's how I know, because this property that you sold me has lost value. It's lost 10% or whatever else, especially if you're in a hot market and they chase after a deal. So you always have certain duties, and duties may be disclosing important information or representing property details in such a manner that somebody could allege you misrepresented those property, that you owed me a higher duty, the highest standard under law, and you knew some things that you didn't tell me about, or you should have known some things that you didn't tell me about. You're going to see this as a reoccurring theme, by the way, but that inevitably you put your interest, your commissions, before my interest as your client, as your customer. And it's a very easy thing to allege. You just have to show preponderance of the evidence in a courtroom. There's the old joke, there's no justice in a courthouse. Right? If you want justice, go to a whorehouse. It's not going to be inside that courthouse. It takes a long time. After COVID, it could be 3-4 years to even get into a trial, and they're just trying to get to your E&O carrier. They're trying to get some sort of recovery. And this is an easy one. This is an easy one to allege because it's the highest duty under the law, and it's something that is fairly common. Number two, misrepresentation. Hey, not only is there a breach of this fiduciary duty, but you negligently or purposefully misrepresented things. And this can be things like fraud. This could be misrepresenting the property condition, the square footage, zoning restrictions, or any other relevant detail you knew and you said something else. And this is a he said, she said. This is why it's so important to put things in writing. So important to have clients sign off on documentation that says, hey, there's no other, and there's nothing else here that is causing you to make this decision, that the contracts generally cover this, that there's nothing outside of here that's being made. It doesn't prevent them, though, from making allegations, and usually it's a he said, she said, where they're making an allegation that you said something during a walkthrough or that you told them something, and they are just making up facts. And again, it's frustrating when you're on the lawsuit, when you're on the receiving end of these things, because quite often you're like, hey, not only is this not true, but I have facts that show it's demonstrably false. But again, all they have to do is get over this little hurdle of getting that lawsuit filed, and there's value to them, especially with an E&O carrier. So don't take it personally. It comes with the territory. If you've never been sued, it's just you haven't been around long enough and you haven't done enough transactions, because it's almost inevitable. I think the average number of lawsuits last time we were checking for an individual in the United States is about 5 during their lifetime. There's some people that take up a huge majority of them, especially if you're in business. You have all sorts of things, employees, you have contracts, you have all sorts of weird disputes. If you're a landlord, you get tenant stuff all the time. You're evicting people. You're taking up a huge number. If you go through divorces, some of us take up more of that number and add to that number. But at the end of the day, it's inevitable at some point, if you're successful in business, that you're going to have to deal with this. And that was an easy one. Number 3 is failure to disclose defects. And this is the thing. If you know about a material defect on a property and you don't disclose it, or you disclose it but it's not adequately disclosed, like they say, I'll give you a real life case here in a second, then you could be sued for failure to disclose. And so I had a real estate agent who handled a property that I sold. And what was so interesting is we disclosed there was termites and there was a complete disclosure. They even had their own inspection, and all they had to allege was, hey, the real estate agent didn't tell us the severity of the termites, even though it had been mitigated, even though they signed off, even though their inspector looked at it. It didn't prevent them from bringing a bogus BS lawsuit. It just sometimes happens. All they're doing is looking for things that they could sue you for, trying to extort some money out of you. And I say extort because that's what it is to me. It's not legal extortion, like all you lawyers out there are like, it's not extortion. It's compulsive, it's frivolous lawsuit. Let's just be straight, right? A lot of these times, these people are just making stuff up. They can get a lawyer and they're litigious, and they're just trying to get an extra 10 grand out of somebody. It sucks. Number 4, negligence. And this is this whole reasonable person standard whenever you get into negligence, and that is the failure to exercise reasonable care, skill, and or diligence in performing their duties. So all I have to say is a reasonable agent would have done X, but you did Y. And realistically, all we need is an expert or someone to say, oh, why did they do that? They shouldn't have done that. They should have done something else. They should have told you, they should have pushed you away from these properties. We knew the market was going to come down because the Fed was raising interest rates. They should have told you not to chase after these properties in 2021, whatever year it was, or 2022. And boy, were they bad in doing so. And you should sue them, whatever. And it's just basically, it's, hey, you should have done something. Or, hey, you should have had this inspected. You should have called in another experts. It's the shoulda, woulda, coulda stuff, right? And all they're trying to say is, a reasonable agent would have done something differently. And again, if you ever get sued by these, try not to take it personal. Just treat it like, hey, if a branch fell on your roof, you don't scream and yell at the branch, right? If you're in business and you're successful at all, you're going to get these things at some point. It's almost inevitable. And the more successful you are, the more of them you attract. So you just have to look at it and say, that's why I carry insurance. That's why I minimize the target on my back. That's why I keep my business, and I'll talk about this, cash poor. So I'm trying to get the money out of it so there's not a big recovery, things like that. And then I'm operating in a business-like manner. I make sure that I'm isolating my assets. I have a great asset protection plan, and I'm operating through an entity. That's why you do these things, so that you're minimizing the target that they're able to go after. Number 5, let's talk about this, breach of contract. You're signing a contract. You're signing an agreement with these people, and quite often, they go through that contract afterwards and they're saying, hey, you did not fulfill this obligation that were laid out and agreed upon. Quite often it's a form document that you don't even read, and they give it to a lawyer who just takes it and says, we can make it an allegation here, we can make an allegation here. And again, quite often it's he said, she said. They're alleging facts that you might say, this is absolute crap, this is not something that I did, this is not something we discussed, we never even had that conversation. And it comes down to the veracity of the individual. And by the way, here's the thing. Unless it's contractually laid out, like you have a merger clause, like, hey, everything was discussed and here's a signature, quite often this is called a question of fact. and they get to go to trial on it. They get to go in front of a jury on it. The judge isn't going to dismiss this case outright. And so what the lawyers are looking at is a way to make it expensive for you or for your carrier, so that if you have E&O, that they're able to get some sort of settlement, and they're looking for nuisance value 99% of the time. And so try not to take it personally. I know it's easy to say, but when you get these types of things, quite often all they're doing is they made a bad decision and they're trying to be not accountable for themselves. They're trying to blame somebody else, and you happen to be somebody that they dealt with, and so they're alleging something else. Number six is dual agency. In other words, you represent a buyer and a seller. I'll just say this, don't do it. It's really attractive to people because you're getting both sides of the commissions, but you open yourself up. It's almost impossible not to have a conflict of interest when you're representing both parties. And so you open yourself up to this allegation, and frankly, it's going to pass muster a lot of the times just on its face because you're getting paid by both parties. It's really difficult when you look at a fiduciary responsibility to not have a conflict of interest when you represent both parties, because how are you putting their interest before your own? Or one interest not at the expense of the other. It is extraordinarily difficult, and I know that agents try to contract around it, but it's not cut and dry. You are open to this claim if you're doing dual agency. I've just always had an issue with it, and I'm like, how do you represent both sides? Unless it's clearly a winner, you always leave yourself open for this. So yes, it's a financial decision. Is it worth the risk? And you might say yes, but there is the risk always present when you're representing the buyer and the seller. I don't care. Like, people do it, but it comes with a risk. Just do it with your eyes open. It's kind of like speeding. I'm not going to tell you to drive 65 when it says 65, right? You might drive 70, 75, but it comes with a risk. That risk is you get a ticket. So do so with your eyes open. And then if you do get the ticket, don't sit there and complain, right? Hey, you knowingly sped. Well, in this case, you're speeding. Conflict. You're doing both sides. Not going to tell you not to do it. I'm not going to say people don't do it. I'm just going to say, here's the problem is you might get yourself dinged once in a while. Do so with your eyes open. Number 7, fair housing. This is coming up. Fair housing violations are always omnipresent. That's because you can't discriminate against anybody. And especially now, if there's lack of inventory, or that somebody's frustrated that they're not able to close a transaction, or you just don't have the time to deal with somebody, maybe it's so busy, or now, or there could just be a simple allegation where they say, you did this act because of an immutable trait of mine, and it's always going to be these things like race, religion, gender, disability, family status, and hey, you're not providing equal services to me. All they have to do is allege it. And you're dealing with that, with potentially that lawsuit. Why do I bring this up? It's because a lot of times people are bringing these things because they're easy to bring, and it's a low hurdle, and it's a nightmare for you to have to deal with, and you'll usually give them money. And unfortunately, it exacerbates itself. And I always use this as an example. I live in Las Vegas. When I drive home from the Las Vegas Strip, and I drive home along those freeways, so we have the 15, for example, I'm popping down there, and I'm driving along, or the Summerlin Parkway, I count the number of billboards that have a lawyers on them. And the last time I did this, and I have about a 15-minute ride, I ran across 26 different billboards. The reason that they advertise is because they're looking for clients and they make money doing this. The reason people continually make these types of claims, and they don't all just go away, is because they make good money doing this. And so agents, sorry, you have a little bit of a bullseye on your back, especially when there's a pullback in the market, and people tend to say, hey, where's the easy money? Unfortunately, there's money in it, because if at a minimum, a lot of times they're just saying, hey, there's a nuisance value to this thing. And the last one is the unauthorized practice of law. So this is what happens. You use the form documents from the Realtors Association. You're using, and somebody's asking you, hey, what does this provision mean? And you say, oh, this is what this provision means. and then something bad goes on, 2 years later in that suit, and they say, you know what, the agent should have told me this. They were practicing law without a license, and I'm going to allege that to see if I can't scare them into giving me more money. It happens. There are some limited exceptions in most under most bar rules about realtors, especially when in transactions. But if you're advising clients on their rights and their obligations underneath the contract, just know that you're opening yourself up. The answer that you should always give is you should talk to your attorneys. That's something that we do here. It's like we have a platinum service where people they're able to call in and check things out. That's why it's there, so that you're actually talking to somebody who has an appropriate license. When you're dealing with realtor, don't expect them to be your lawyer. And if you are the realtor, don't try to be the lawyer. Always be like, hey, you need to have that reviewed by somebody else. You might give them your opinion, but make sure you're putting it in writing. But you need to seek appropriate professional advice. This is what this generally says, but you need to seek your own counsel. I'm not your attorney. I'm not, blah, blah, blah. And so you're doing a little bit of cover at your butt. And that just goes because, hey, if you are prepping a document for somebody, you're opening yourself up for that. Now, again, all 8 of these, there's no way I can prevent them, right? If you're out there in business, you are susceptible. And that's why we always tell agents to put their business inside of a protected box called a limited liability entity. And let me just explain it like this. We want your business separate from you. So your business goes into the box. Here's your business. It's sitting inside that box. Your real estate business, when you're acting on behalf of clients, it stays in that box. Anything that happens business-wise stays in that limited liability entity, either an LLC or a corporation, depending on your state, and you're going to act within that box. On the same token, if you do something personally, your business is isolated from that too. So if I fill in the blank, I get a divorce, I get into a car accident, I yell at somebody and offend them and they sue me for whatever, hey, you're harassing me or whatever. Hey, you said something or you wrote something that I don't think is fair, or, and I'm going to sue you. All that stuff is outside of that box. So we have the box and we have your stuff. Now, inside that box, you may have money, and somebody, when they go after you, and let's say that you have not been removing the funds from your entity. So I have a real estate business and I have not been paying myself out the profits, or I'm not paying myself a salary. There's money inside that box. We got the box, there's a claim inside, and there's money. Now, if I remove the money, you're opening yourself up to this fraudulent conveyance. Hey, it wasn't done in the regular course of business. You removed assets from me. You're susceptible to that. I'm not going to say don't do it. Just know that there's another claim that could be made against you if they're successful in their litigation. And I want to be clear about that they have to be successful in their litigation. They actually have to have a claim. You have to not pay it. And then you have to say, hey, you took assets that were available to me. What you don't want is to be sitting there worrying about that, because there's a bunch of money inside your real estate agent box. You got to get that money out and at least get it to your personal realm. My personal view is that you take your non-risk assets like your cash, like stocks, and you isolate them in an entity like an LLC, be like Wyoming, where nobody can see it, nobody can take it from you. Once that money's in there, it's pretty darn safe. And we take our risk assets like our real estate and we isolate those in a different type of structure. Usually it's going to be a series of LLCs, a holding entity with sub-LLCs that actually hold the property, maybe land trust. If you're in California, maybe Wyoming statutory trust to avoid the franchise tax. But we're using a structure to isolate the risk assets from my business. All of that's isolated from me because I can never stop the liability for me, because I'm always going to go out there and talk. I'm always going to interact with people. I'm going to drive a car. I could hit a busload of nuns and get the heck suit out of me. I got to have these things isolated from me so that they can't take it. But at a minimum, you take your real estate business and isolate it, and you make sure it's not sitting there flush with cash. I know some of you guys are super successful and you like looking at the bank account with huge amounts of cash in it. And I would say, number one, watch out, because banks are failing left and right. Make sure that you're not above the FDIC insurance levels. but also let's make sure we get it out of the business, because there's always liability in that business. And before you say, but I'm not doing anything wrong, just remember you don't have to do anything wrong. They just have to claim that you did. And you may have other agents, you may have employees, you may have people that work for you, or you may be driving while working for your business, and you're on a way to an appointment and they allege that you were acting within the scope of your business, and they get you that way too. So you always want to make sure that the business does not sit there with a whole bunch of assets. We get those out, and we want to make sure that that business is isolated from you. And when I say isolated, LLC or an S corp usually does the trick, and that LLC, by the way, can be taxed as an S corp, so we can still get the same tax benefits, but we want to make sure it's isolated. Don't worry. If you want to learn more on this, you could always reach out to us, or I also have hundreds of videos on this very channel that you can review. But the whole purpose here, guys, for you real estate agents is to understand what may be lurking around that corner and how you can isolate that liability, minimize its impact on your life, and allow you to go forward and be very successful without always looking over your shoulder. Because guess what? If you're a very successful agent, at some point in your life, someone's going to try to take a little piece of that, and you want to make sure that you are the smallest target possible with the least amount of money that you could potentially lose, so that you can get rid of that case quickly. The people that get stuck in drawn out suits are the ones where there's something to take at the end of the day from the other party, and they can see it, they know it's there. Maybe you didn't operate through an LLC, maybe you didn't operate through a corporation, and they know that if they can get liability on you, they could garnish you forever, or they can go get your other assets, including possibly the equity in your house. Maybe it's you have other properties, maybe you have other businesses, rentals, whatever, and they think they can get it. Even an IRA, they may look at it and say, I think I can get to that. And so they have no reason to settle, because they have everything to gain if they can win that lawsuit, because they have such an amount that they can collect. They know it, you know it, your counsel knows it, and you're like, crud. If only I had isolated that liability and structured before the claim was made. That's important. Can't do this after the fact. You got to do this proactively. So if you're a real estate agent or a broker, and you're like, oh gosh, I am worried about my exposure, please reach out. We'll talk to you and we'll see what we can do to isolate that liability, minimize that risk. And by the way, when you do that type of structure, it often puts money back in your pocket, because the tax benefits are so great when you structure things appropriately. So anyway, so that was the top 8. Let's do 8 things that real estate agents are getting sued on, the top 8 lawsuits that we're seeing right now against real estate agents, how to minimize it, how to avoid it if all certainly possible. Nobody sues the homeless folks, so we want to make sure that your business isn't sitting there looking like it's Daddy Richie. You want to make sure that you're looking kind of like, hey, there's not a lot for me to go after here, so that at a minimum, if they come after you, that they're just looking at E&O coverage. If you don't have E&O coverage, that you're still able to get rid of the suit because there's nothing for them to collect. And once they see that, they tend to go away. Or better yet, if they can't see assets, they tend to never even bring the suit in the first place. Follow that, and you'll be a lot better off from a peace of mind and financial standpoint. But anyway, that was it. 8 types of lawsuits right now, the top 8 lawsuits being brought against real estate agents.